Welcome to CenturyLink Conferencing. Please enter your passcode followed by the pound. Please hold while I confirm your passcode. Thank you. Your passcode is confirmed. When you hear the tone, you will be the fourth person to join the meeting.
I should even say that,
We did really think about it.
So when we want to turn that one off,
Well, we'll get started. Welcome, everyone, to our Zoom meeting. And good news is we all survived the session. I And we'll talk about that some this morning, and begin planning for your head. We have 2 new members. I don't think either they're not here. One is Kevin Bryant, who's General Counsel for Crow Holdings in Dallas. He's on the Executive Committee of the Real Estate Council. He's a member of the Policy Committee for the Real Estate Roundtable, and he volunteers on various different things in the Dallas area and has been appointed by the governor. And the second new member, also appointed by Governor Abbott, is Rachel Ratz, I think is her name, an investor and entrepreneur in Houston. And before starting her own company, she was most recently head of strategy at Vista Propellants and Logistics. She volunteers on various different things in Houston, including the Navy SEAL Foundation, which I suppose is because her husband is like a Navy SEAL. So we'll welcome them to our to the council, and we're losing Carlos Amaral, and we appreciate his service to the council, and we look forward to working with the new members. We may have some more new members later in the summer, but we'll announce those when they come in. David, call the roll, please.
Chief Justice Heck.
Here.
Presiding Judge Keller. Here. Judge Gary Blair.
Here.
Justice Bill Boyce.
Here by phone.
Mr. Kevin Bryant. Miss Sonia Clayton.
Here.
Senator Brandon Creighton. Judge Bill Gravel.
Here by phone.
Miss Allison Ho.
Here.
Judge Scott Jenkins. Representative Jeff Leach.
Here by phone.
Judge Kelly Moore. Representative Andrew Murr.
Here.
Judge Valencia Nash.
Here.
Miss Rachel Ratz. Chief Justice.
Here by phone.
Oh, there she is. Welcome.
Chief Justice.
Thank you. I'm excited to be here.
Chief Justice Sherry Raddick.
Here.
Mr. Kenneth Sachs.
Present.
Judge Polly Spencer. Judge Ed Spillane.
Here.
Judge Vivian Torres.
Here.
Mr. Evan Young.
Here.
Senator Judah Zaffarini.
Present.
I hope you've seen the minutes for February meeting, any corrections or objections to the minutes. Without objection, they'll be approved. And we'll go to reports. First one is from the Indigent Defense Commission. Jeff.
Hey, good morning, everyone. My name is Jeff Burkhardt. I'm the director of the Texas Indigent Defense Commission. You have a written update in your materials. I just want to highlight 3 things briefly. First, we had a good session. We did not get everything we asked for, but TIDC is up an additional $14 million a year. Second, most of those funds we plan to invest in improvement grants. Improvement grants are just what they sound like. We're trying to improve the state of indigent defense across Texas. To give you a few examples of that, TIDC recently increased our sustainability funding to the Regional Public Defender Office for capital cases, which provides death penalty representation in 181 counties to 2/3. Similarly, we just increased sustainability funding for rural regional public defender offices. These are public defender offices for very small counties, the 100,000 population or less, up to 2/3. And we have some substantial urban grants that are pending as well, one for a public defender office in Travis County, and another for a managed assigned counsel system in Harris County. So those are still pending. Just to give you a few examples, though, of how we're trying to improve indigent defense in Texas. And lastly, the only thing I'll mention is we just kicked off our leadership and mentoring program. This is a new program that is statewide in Texas. We have 25 mentors, 25 mentees who are paired up. We are partnering with the Texas Criminal Defense Lawyers Association and Gideon's Promise on this, and we're pretty excited about it. We had the kickoff, I think it was 2 weeks ago down in San Antonio. So that's it, unless there are any questions.
Any questions of Jeff?
Thank you,
Thank you, Jeff. Great report. We'll turn to the Centers of Excellence and consideration of approval of designation. Jeffrey Sunakawa.
Good morning. My name is Jeffrey Sunakawa. I'm currently the Acting Director of Research and Court Services. Most of you remember Scott Griffith, who recently left for Vermont. been asked to step into that role. So I've been in the role for about 3 months. Been with OCA since about last November. So pleasure to be here. I think most of you are familiar with the program, the Centers of Excellence, but for those of you who are not familiar, I just want to give a brief background on what the program is. The Centers of Excellence program is an initiative that was created in collaboration with the Public Trust and Confidence Committee out of the Texas Judicial Council. A lot of support from Senator Zaffarini and administrative support from the Office of Court Administration. The program is open to every court throughout the entire state of Texas at every level. The program is designed to have courts go through a very thorough process of evaluating their processes, their operations, and their management. They conduct performance inventories, and they self-assess where they are on different levels. They also assess themselves on compliance areas where statutorily and legally they're required to comply with state laws. OCA staff would then take those inventories, and we would audit in one term, but evaluation of the court to see where they stand. We focus on 4 areas: governance, case flow management, access and fairness, and court operations. We take best practices that are used around the country for the judiciary and for courts, and we apply those to the standards that we would expect courts to meet or to be designated as a Centers of Excellence. This was actually launched last March, and here we are about 15 months later. We would actually like to express our thanks to Judge Missy Mederi and Judge Anna Klein for working with us over the last 15 months. It's been a process that has evolved into a very streamlined program, and that we think that is successful in evaluating courts and their management. So today, I'm actually pleased to announce that we have 2 courts that we'd like to nominate as Judicial Centers of Excellence. The first that I would like to nominate is the 347th District Court in Nueces County, Judge Missy Mederi. By way of background, Judge Mederi became a judge in Nueces in 2002. She became the judge for the 347th District in 2011. She's currently presiding judge of the 5th Administrative Judicial District for the state of Texas. She started with her court back in May of last year. The process, their initial performance evaluation noted that they were lacking in a couple areas: case flow management and governance. And we spent months and months working with Judge Mederi, with her staff, Mary Lee Roberts, the court administrator down there, and Andrew Garcia, the court manager for the court. And after months and months and months of working with them, they have worked to improve in every single area on performance, and we appreciate their work, and we feel like they've done an outstanding job of performance and compliance. One of the things I wanted to highlight about Judge Mederi's court is that she is the first in the state to create a child-friendly witness room. So she actually has a room set up back in her chambers for children that are required to testify in court. So they're in a safe environment, they're in a very loving environment. When they meet with attorneys or the judge, it's a very, very safe room. She's very proud of it, and it's very successful in her court. The other court we'd like to nominate today is the 214th District Court, also in Nueces County, Judge Anna Klein. Judge Klein was elected to the bench in 2017, and she's currently the local administrative judge down there. Judge Klein and her court began this process at the same time as Judge Mederi. These 2 courts work simultaneously on a lot of projects and do really well. They share experiences, they share successes, they share failures. We wanted to make sure to recognize their court manager, Gabriela Dennis, and also court administrator, Mary Lee Roberts. They worked on their performance measures in the very beginning and noted that they were lacking on areas such as publishing performance data, as well as tracking trial date certainty. So we get down into the weeds and making sure that courts are doing everything they possibly can to meet really high standards. Highlight of Judge Klein's court. Judge Klein is very active in finding grant funding to improve the administration and operations of her court. Currently, she's operating a felony domestic violence court that she's very proud of by use of grant funding, and she's made a lot of technological improvements. I think when I was there was a 64 and 84 inch television screen in a box waiting to be displayed somewhere. So It has been a pleasure to work with all these individuals. They've worked very hard. I should have brought it, but there is a 4-inch notebook in our office of documents and reports that they have gathered to prove to us that they are actual. So my colleague Michael Smith is showing me that. This is one. So they've worked very hard, and we are grateful and appreciative. And Chief Justice, based on our review and our assessment, we believe they've met all the standards to be considered a judicial centers of excellence.
Judge Medary, tell us what interested you in pursuing this designation.
When David Slayton brought this to the PJs and said that the Judicial Council had started the Center of Excellence, I try to strive in my court to do anything that I can to make it obviously the fairest court and have it the access for the public. And so when David brought it to the presiding judges, I thought what a great way to not only make an example for my county, Nueces County, but also to make an example for the entire 5th region. As you all know, I have 11 counties underneath me, and I am not only humbled and honored to be able to be nominated for this award, but I can't wait to bring it back to Nueces County, to make Nueces County proud, but also to bring it back to the entire 5th region and hopefully have a lot of other courts join me in this journey for Centers of Excellence. Thank you.
And Judge Klein, what about you?
Well, I'm the local administrative judge for Nueces County, and I was very excited when Judge Medary brought the idea to me, and together we were able to pinpoint our issues. I wasn't born in a country where there was a judicial process established, so now being the local administrative judge in Nueces County, it was crucial to me that we have the process available to everybody, a clear process, especially to the people who don't have the attorneys and can navigate the process by themselves.
Wonderful.
Thank you.
So is there a motion that we designate?
Second the motion.
Any further discussion? All in favor, say aye.
Aye.
Opposed? Motion carries. Congratulations.
Thank you. If I could just say one more thing, I want to thank Judge Klein, obviously, for working so hard with me, but I can tell you that this could not have been done without our court coordinator, my court coordinator, Andrew Garcia, and then Gabby Dennis, also, who is Judge Klein's coordinator, and really could not have been done without our court administrator, Marilee Roberts. So we owe a great amount of thanks to them. They are just rock stars and worked with us every lunch hour, because we're full-time courts. So it was lunch hours and after work that we worked on this. So I just would like to say thank you very much to our team. You guys were awesome.
Thank you. David has the award. We're going to present them in the courtroom after we finish the meeting here, so the press can be present, but do a better job. But that's what we'll have to see. I was the regional presiding judge for several months while we were waiting Judge Medary's appointment, and I should say Nina was the presiding judge. I was the assistant, and it's a lot of work, and but not just a lot of work, but we really count on the regional presiding judges to make sure that the judges in the region are coordinating with each other, and when they're changing benches and getting visiting judges in, and so those were really important positions, and we're very proud of them. And 100 years ago, I was a local administrative judge in Dallas, and that's a real honor. And, it's a lot of work too, and so Judge Klein, we know you're a great leader down there. Thank you, and thanks to the staff for all of your work on this. It really sets a great example. That's what we're trying to do through this, is to set an example to the 3,210 judges that we have in Texas, and then to the country. This is the way to court should act. So thanks very much.
Thank you.
Yes, Senator.
I'm hoping that going forward, we can work through the presiding judges and the administrative judges to work in sort of a pyramid, working through them so that they can encourage the judges who work with them, or under them, I should say,
Yeah,
to ensure that we have more courts of excellence.
that's a good idea. We'll do that. We'll bring that up with the presiding judges.
And Senator, I will tell you that Judge Klein and I have also discussed this as well, and we would be happy to be used by any of you all to be mentoring courts to any of the courts in Texas.
As is our staff.
Wonderful.
Thank you.
Great. You were a real supporter of this project. Absolutely. And it's working.
It's working.
Good.
I'd like to see a lot more.
Yep.
But thrilled that we have two after only 15 months. I think that's terrific. And looking at those figures, going from these figures to 100% in each of those 10 categories, I think that is terrific.
Just so everyone knows, I remember sitting with Judge Mederi last May, I guess it was, and going through what the council had put forward as to how a court would become a center of excellence, and I beginning to identify all the areas, and she said, oh wow, this is going to be a lot of work. So I want everyone to understand, this does not come easy, and it won't come easy to any court. It is doable, obviously. It takes maybe a 4-inch notebook to get there, but I know they worked very, very hard, because once we began to look at the issues that we had identified as what we thought were important to making a court a center of excellence, they were able to identify those areas and make the improvements. So my congratulations to them as well for all their work.
Great. Well, we'll go to the legislative update. Megan, Jennifer.
Good morning, everyone. I'm happy to be here with y'all. My name is Megan LaVoy. I'm the Director of Public Affairs here at OCA. I'm going to give you a brief update, mainly on the Judicial Council bills that passed this session, and there's going to touch on a couple of other issues too, and then Jennifer is going to give an update on the budget. So I wanted to start just by saying that I think that the judiciary overall had a really successful session, probably one of the most successful since I've been here, especially with the budget. So we'll start with that. These are some legislative statistics. As you can see, about 20% of the House bills that were filed passed, 18% of the Senate bills, and we get these statistics from Telecon, which is a tracking service that we use. And I don't think that those numbers are really out of the norm. I know Senator Zaffarini is the queen of legislative statistics, so she might have other.
The king.
Also on the opposite side of the screen is OCA fiscal note statistics. So if you don't know what a fiscal note is, it's the cost of the bill that's attached to every bill that has a hearing, also has an analysis of the bill. And OCA does the second most of any state agency. The only other agency that does more than OCA is the comptroller, who has to do a fiscal note for every bill. So you can see since the 82nd session, our numbers have doubled. So it's a lot of work and takes a lot of effort during session. I made this chart, or actually Meredith made this chart, but it shows all of the 17 legislative priorities that the council voted on last fall. The ones that have the solid circles are the ones that passed. The ones that have dotted or dashed circles are partially passed this session, and the ones that are not circled did not make it through the process. But I thought it was a good visual for y'all to see. So I'm going to start with something that we're extremely proud of that passed at Senate Bill 31, which expands by Senator Zaffarini and Representative Smithy, that expands our guardianship compliance pilot program statewide. It also renames the program to the Guardianship Abuse, Fraud, and Exploitation Deterrence Program. This is legislation that the council has supported not only this session, but the session previous, and actually made it through the process last session, but was vetoed. So excited. One of our the council's chief bills, and it also was fully funded in the budget, which Jennifer will talk about. Another big bill that the council supported was House Bill 2384, which is the judicial pay increase by Representative Leach and Senator Huffman. This overhauls judicial pay in this state. As you all know, judges hadn't received increase since 2013. Prior to that was 2007. It's been a highly political issue, very difficult for judges in the state to get regular increases, and now we have a whole new plan. Very excited about it. It's a tiered pay system based on longevity. So judges that have 0 to 4 years of experience, they're set at the base salary, which is currently $140 for district judges, $154 for courts of appeals justices, and $168,000 for Supreme Court and CCA justices and judges. And also, under this plan, since 0 to 4 years of experience, judges, legislative retirement doesn't increase under this plan as well. Judges 4 to 8 years of service receive 110% of the base pay. Judges that have 8 to 12 years of experience receive 120% of the base pay. And then longevity pay is also changed under this new law. Currently, judges receive longevity pay after 16 years of service, and it's 3.1% of their salary. That's changed under this to receiving a longevity pay at 12 years of service, and it raises to 5% of their salary.
Yes, Senator.
I still would like to see an addition to that based on the courts of excellence, so that any court that's certified as a court of excellence would get additional pay for that judge. I would love to see that going forward.
Yeah.
We talked about it before, but we were still trying to get the basic pay raise.
Right.
And now we have this, maybe that would be the next step.
That was actually something, this plan by Senator Huffman and Representative Leach was developed last fall. And it stemmed from some of the interim hearings that were held. There was an interim commission to study judicial salaries, and that was that was brought up in the hearing, Senator Zaffarini. Also under this bill, the retirement contribution is increased for judges from 7.5% to 9.5%. That's in line with state employees. The child support, child protection judges are going to be receiving 90% of the base pay of a district judge, which is $140,000. That was a recommendation from the Judicial Compensation Commission. And then county court at law judges and prosecutors are also on this tiered system. I gave an update to the clerks about 2 weeks ago, and we spent about 30 minutes on this bill alone, so please let me know if you have any questions. But we're very thankful to Representative Leach and Senator Huffman for their leadership, and feel like judges now have a positive pathway forward in expecting pay increases. A big issue for this session obviously was Hurricane Harvey and recovering from Hurricane Harvey, and the judiciary was definitely part of that. Senate Bill 40 by Senator Zaffarini and Representative Leach comes from recommendations from the Public Trust and Confidence Committee. This is mainly dealing with administrative aspect of keeping the judiciary running during a disaster. It allows emergency orders to be extended up to 90 days. Currently it's 30 days, and also allows the Chief Justice to renew those orders without consent of the full court. I believe there was 11 emergency orders, and multiple of them had to be renewed several times following Hurricane Harvey. Another thing that was discussed in the Public Trust and Confidence Committee is having a central figure for the court system and the local courts to turn to during times of disaster, and especially when county judges are dealing with making sure there's food and water and shelter for the individuals in the community. And so what was discussed was having that individual be the administrative presiding judge of the judicial region. And so under this bill, it also authorizes the PJ to operate to allow court to operate in another precinct or county. This was stemming from a specific justice of the peace in Harris County that could not find space in their precinct to operate court, so they had to get an emergency order from the Supreme Court to do so, and I believe that order was extended multiple times over a year. And also allows the presiding judge of the administrative region to designate the terms and sessions of the court when the court is precluded from holding court because of disaster. One thing too I should mention that was mentioned in some of the hearings for this bill is that the court system never shut down during Harvey. We had clerks that were processing cases via e-filing while their homes were flooded, sitting at their coffee table or their kitchen table, and we have pictures of that. And that was mentioned in the hearing, and also that a couple of weeks after Hurricane Harvey, Florida actually had a hurricane and their e-filing system went down, and Texas's e-filing system never went down during the disaster, so that's something to be proud of. The next couple of bills, I apologize for that there's so much text on them, but these are all the mental health bills that stem from or come from the council's mental health committee. A lot of them, several of them are complicated, so I put a lot of text on there so you can digest it a little bit better. House Bill 601 by Representative Price and Senator Zaffarini is a cleanup bill from our big mental health bill, Senate Bill 1326 from the 85th legislative session. One of the things that during the interim that was discovered, so Senate Bill 1326 required magistrates to order mental health assessments if they suspected there was a mental health condition in an individual. And in the interim, it was discovered that when they were doing these assessments, the individual was not all the time being interviewed, that some of the information that was included in these assessments was from third parties, such as a jailer, saying that they saw such and such happening. And so 601 requires that the individual, or allows the magistrate to order that the individual be interviewed. It also allows for the Texas Judicial Council to adopt rules for reporting on those assessments, so we get good data back from the courts. Also, stemming from this committee, or the Mental Health Committee, was that TDCJ, upon an individual being incarcerated, was not always getting all of the mental health records that followed the defendant, and so this clarifies that those mental health assessments and any other records be transferred to TDCJ so they get a full picture. House Bill 598, also from the Mental Health Committee, and this is stemming also too from Senate Bill 1326, was discovered that some magistrates, part-time associate judges, and masters were not eligible to receive judicial training funds from the Court of Criminal Appeals, so that this clarifies in statute that that they can receive that funding for training. Senate Bill 362 by Senator Huffman and Representative Price is our civil commitment bill. It addresses multiple issues related to court-ordered mental health treatment. The civil commitment statutes in the Health and Safety Code, sometimes difficult for judges to read, so it reorganizes them and then also clarifies conditions under which a judge may order temporary outpatient, extended inpatient, outpatient, or outpatient mental health services. Also allows courts to set status conferences. A big portion of this bill requires publicly funded entities coordinate admission, treatment plans, and discharge plans for local mental health authority, and also provide medication upon release. As you know, when an individual is released from one of these facilities, they often have a follow-up doctor's appointment, but it might not be until a week or two later, and if they're not provided medication, they'll obviously have a relapse. at that time. So that was a big part of the bill. There's also training components for judges on outpatient services in this bill, and then also requires the Supreme Court to adopt rules related to emergency detention. Senate Bill 562, which is the last of the mental health bills, deals with manifest dangerousness, also by Senator Zaffarini and Representative Price. So currently, how the process works when an individual is found incompetent to stand trial and is also charged with a violent offense, they have to go to a maximum security facility and be evaluated by the Manifest Dangerous Review Board, which is housed in HHSC. As many of you know, the forensic bed waiting list is lengthy. Sometimes it could be 4 or 5 months or even longer before an individual would be able to get into that facility. So the Mental Health Committee looked at this issue and decided that, the recommendation was put into Senate Bill 562, that to require the Health and Human Services Commission to transfer a defendant from a maximum security unit to a non-maximum security unit. So basically what happens is that review is held up front so that somebody doesn't have to wait 5 or 6 months to go to Vernon and wait for a forensic bed to open. So it streamlines the process significantly. Also, an amendment that was added to this bill requires counties with a population above 200,000 to establish a mental health treatment court, as long as there's funding available either from the state or federal funding, and it requires counties to actively seek that funding.
Let me just add there that the courts across the country are finally taking a look at mental health issues and trying to address them more productively. And the Conference of Chief Justices has got an initiative that we're going to work on in July. There was just a national meeting out in Seattle a week or so ago. David was there, Christy was there, and others. Really feel like we're making some strides there, but Texas has really been in the lead on this, and the Judicial Commission on Mental Health that the Court of Criminal Appeals and the Supreme Court created has already done a lot of work, got more funding from the legislature. Christy's doing a great job with her staff, and I think we're going to make some real progress on this. And I happened to see Tom Luce the other day, who's worked on these issues for a long time, and he was very effusive about what Texas courts are doing. So it's all a very good report and well recognized by the legislatures.
Moving on quickly, Jennifer's going to cover this, but I wanted to mention it because it was a recommendation from the Data Committee for Uniform Case Management System. OCA received funding to develop this, and it's going to allow the courts or OCA to collect case level data. Also, having Uniform Case Management System is going to focus on counties that are under 20,000, which is half of the counties in our state. But it's also necessary to comply with federal CPS orders. Having a Uniform Case Management System was part of the Governor's School Safety Plan because it will increase more accurate reporting to the NICS system, which is used for federal firearm background checks. Also going to be helpful in bail and provide magistrates with access to data. And then the biggest thing, and I think the big transformation for the judiciary is that it will allow us to start collecting case level data. House Bill 2955 by Representative Price and Senator Zaffarini transfers oversight of specialty courts, DWI courts, drug courts to the judiciary. OCA is going to start providing more technical assistance, monitoring these specialty courts for best practices, and also just be a good coordinator of exchange of information between the Governor's Criminal Justice Division, the judiciary, and the courts. Senate Bill 2342 by Senator Creighton and Representative Leach increases justice of the peace jurisdiction, or civil jurisdiction, and constitutional county court civil jurisdiction up to $20,000. It's currently at $10,000. Increases the county court at law civil jurisdiction up to $250,000. It's currently $200,000. And then also requires a 12-person jury for in county court at law cases that the amount in controversy exceeds $250,000. Senate Bill 1887 came from the Juvenile Justice Committee dealing with dually involved youth, and it's by Senator Huffman and Representative Murr. This allows juvenile judges to transfer cases to CPS judges when the same child is involved. So if a juvenile has had a theft or committed another offense, but is also in the CPS system, it will allow the CPS judge to handle both cases. We've seen district judges are allowed to do that now, and many district judges have dual dockets, such as Judge Byrne here in Travis County. And we've seen great outcomes when it's one judge handling both cases so they can coordinate services. Senate Bill 49 is our court security cleanup bill from Senate Bill 42, the Judge Julie Kasurik Act from the 85th legislative session. So in the interim, it's discovered that there were some loopholes in some of the reports that were filed with the Ethics Commission and with county clerk's offices that still allowed judges information such as their address to be disclosed to the public. And so we closed those loopholes. It also requires a little bit more reporting from OCA's security director, Hector Gomez, who I'm sure many of y'all know. He has been traveling the state for the past year and a half, educating judges about court security and doing court security assessments. Moving on to vetoed bills that were judicial council bills. Senate Bill 467, which dealt with the Judicial Commission, or the State Commission on Judicial Conduct. It was a transparency bill. Senate Bill 536 would have established guardianship specialty courts, and Senate Bill 667 was guardianship of last resort, establishing those offices in counties.
But you didn't say all three by Zachary.
I was trying to, you know.
I was thinking about that.
Well, thank you.
You have way many more bills that were passed that helped the judiciary than were vetoed. So, also bills that didn't make it through the process that were judicial council bills, judicial qualification modifications. There were some jurisdiction changes and also qualifications changes to age, like moving the age to be a statutory county judge from 25 to 30. And then the terms were increased in those bills. That one didn't pass. Our big issue that was also an issue last session, our pretrial bail reform that would have established required judges to use a risk assessment and then also have preventative detention. Those didn't make it through. And then juvenile class C diversion, which would have finished our work stemming from truancy and school ticketing, didn't make it through the process either. But I think we're going to work on them next session.
Senator, yes.
You may remember how much time we spent discussing the judicial qualifications here in the Judicial Council, and before that, even committee. So I think that reflected the controversy in the legislature. There was even more discussion at that point. So I think we probably were a good test for what was to come, because it's very important, but very complex.
It's interesting too, because on the judicial qualification, there was actually three bills that were filed focusing on length of terms, and I think one was 8 and one was 10, and I don't think any of them got hearings because leadership had some questions about it. These bills are not, the next three bills are not judicial council bills, but pretty significant to the judiciary, and I'm going to go through them really quick. I think I'm going over my time, but Senate Bill 346 reorganized criminal court costs. This bill stemmed from an interim hearing in Senate State Affairs, also by Senator Zaffery and Representative Leach. So it consolidated court costs, had to deal with trying to solve some constitutional issues where some court costs were not being used for criminal justice purposes, and courts across the state were striking them down, including the Court of Criminal Appeals, and creating big holes in the state budget. So this bill attempts, and I think did a pretty good job to resolve that issue. So now a convicted defendant only pays 2 court costs, a state court cost, consolidated court cost, and a local consolidated court cost, plus any fines and reimbursement fees. If you ever want to see the crazy spreadsheet that David Slayton made to get this bill where it needs to be, ask him about it and he'll show you. It's
Chief, if I may add, really it has my name and Representative Leach, but it was OCA who did the work. So thank you, David and staff, for doing all that, because it really should say my OCA staff.
Yeah, it's and it's revenue neutral. I think it's like revenue positive by $500,000. So lots of work on this bill. It also included Senate Bill 1913, which was our big fines and fees bill from last session by Senator Zaffery, and included a cleanup to that bill also. And really quickly, House Bill 3040 creates a judicial selection commission. There has been judicial selection commissions created in the past. This one is pretty detailed about what the commission is supposed to look at. It's staffed by OCA. The membership is very interesting. You can see 4 members appointed by the governor, the lieutenant governor, and the House Speaker, and then there's specific qualifications in there. That one member from each of those appointments can't be the member of the same party as the governor, the lieutenant governor, or the speaker. And then Supreme Court, Court of Criminal Appeals, and the State Bar each get a member. Senate Bill 891 is the big court omnibus bill. There's lots of things in that bill that deal with the judiciary. Its main purpose is to create new courts. There were 9 new district courts and 8 new statutory county courts created this session. Also in that bill, OCA received funding to renew its weighted caseload study, and that's how we determine and give data to the legislature on where new courts should be created. In the past, it's only been done for district courts, and this year it's also going to be done for county courts at law. And this bill also repealed the collection improvement program. There's a ton more bills that I wish I could cover for y'all, but they are all covered in our legislative update, which you each have a copy of. And I want to thank Brandon Bellows, who's our Assistant General Counsel, and Jared Opperman, who's our law clerk, for all their hard work on getting this document together and working on all the summaries. They did a great job. Happy to answer any questions. If not, Jennifer can move on to the budget.
Questions of Megan? Thank you, Megan. Jennifer?
Thank you. I'm Jennifer Henry. I'm the Chief Financial Officer for the Office of Court Administration. I'm going to echo what Megan said about how successful this legislative session has been, not just for legislation, but on the funding side. I've only worked for 2 agencies in my 31 years in state government, and this was by far my the best outcome, I feel, for the funding, especially for OCA. So let's talk about what we have here. The overall baseline budget request for the judicial branch, I'm sorry for standing in front of y'all, totaled $669 million. That's excluding retirement and benefits. The judicial courts and agencies submitted exceptional item requests totaling $166 million. So that brought the total request to $835 million. An additional 69 FTEs were requested. In all, the agencies received $799 million, 1,540.6 FTEs. This is an increase of 63.8 FTEs for the judicial branch. If we were to include the retirements and benefits figures, the total budget would be $955 million. It's a $72 million increase, or 9% for the judicial branch overall. Contingency riders added $41 million to the conference committee report. I point that out because the numbers I'm presenting include the contingency riders, but if you were to look at the conference committee report today, you won't see it in the individual bill patterns. I just wanted to make that clear. So here is a representation I borrowed from the LBB that shows the entire state by article and how the funding falls. We're right here in the middle. We're a tiny little dot. We make up 0.4% of the entire state's budget. Let's talk about method of finance. General revenue appropriated is $408 million. Our GRD accounts make up $191 million. Federal funds, $3.5 million, and other funds is $197 million to bring us, on the retirement, $156 million. That brings us to the $955. Here's a pie chart showing that the judicial branch is half of it's funded by general revenue, and then equally across our GRD and our other funds makes up the balance of the judicial branch funding. Now I'm going to go through some items of significance for each of the judicial branch agencies. I'll try to go quickly because I know we've got a lot on the agenda. Looking at the Supreme Court, they received salary increase for senior staff attorneys, law clerks, clerks, and administrative staff. The judicial pay bill adds $473,000. Basic civil legal services increased by $17.6 million in GR, which brings them back to the 2010-2011 funding levels, which is what they requested. So there's a total of $68 million total funding in the GAA. An increase of $3 million in GR to provide additional legal services to veterans and their families, which brings them to $6 million in total funding now. And an additional $400,000 to the sexual assault program account, and it restores appropriations to up to $10 million. They also received $250,000 in GR for the development of a training program to educate and inform judges and their staffs on available mental health resources. This funding was also provided to the Court of Criminal Appeals. Court of Criminal Appeals received salary increase money for their staff attorneys, law clerks, clerks, and administrative staff. And when I'm talking about salary increase, we're talking about 2.8%. They received an additional $3.5 million in the training fund, which brings it up to match the biennial revenue estimate that the comptroller puts out. So they got extra funding for that. And then judicial pay increased their budget by $515,000. In the intermediate courts of appeals, they were approved for one staff attorney to assist their visiting judges with processing cases. That FTE is actually going to reside in the Office of Court Administration's budget. And we received $258,000 to fund that position and other operating costs. They also received a rider that allows them to use their visiting judge money that's in the comptroller judiciary section to employ or contract for a staff attorney to assist judges in cases that are above and beyond their ordinary case level. Right now, they can only spend that money on visiting judges. They'll be able to use that money now towards attorney resources. And that rider is actually in the comptroller's bill pattern. Judicial pay increased the intermediate appellate courts by $2.9 million. State prosecuting attorney also received salary increases for their state prosecutors and their administrative assistant. The judicial pay bill added $8,000. It's so low because she doesn't kick in until the second half of the second year. State Commission on Judicial Conduct, salary increase for the staff and increasing the ED to an exempt group 4. State Law Library, salary increase for staff, assistant director, and increase the ED to exempt group 2 from group 1. And they received $170,000 in GR to maintain their remote access to digital legal reference materials to keep them at the current level. They were going to have to take a cut, so they got to keep the current services. Office of Capital and Forensic Writs, salary increase for the attorneys and mitigation specialists, bringing the ED up to group 4. And they received $965,000 for 4 positions, 3 attorneys and a mitigation specialist. And 2 of the attorneys are dedicated to representing inmates in non-capital cases where questionable forensic science contributed to their conviction. Office of Court Administration received a lot of new funding this biennium. $5 million and 28 FTEs for the guardianship compliance program that we're very happy to have. Now we're up statewide. $3.7 million and 18 FTEs for 9 new child protection courts. That brings our total children's courts level to 76, which includes the child support. So 57% of our child support judges and court coordinators are eligible to retire in the next biennium. 20% of our CPC staff can retire. It's a large number. So we requested money to help pay for their annual lump sums if they were to exercise that option. We received $300,000 for that, which we're very grateful for. $29 million for the uniform case management system that Megan mentioned earlier. More than half of this is to be paid from the e-filing account. The other half comes from general revenue. Forensic Science Commission received estimated authority.
Hold on a second.
On that previous slide, I'd just like to point out that the guardianship compliance program now has that new name.
Yes,
Guardianship
yes, ma'am.
Abuse, Fraud, and Exploitation.
Right.
Reform program. That's how we passed it.
Right. Forensic Science Commission, they receive revenues for all their licensing. They now have estimated authority, so they have access to all of that money now. They now have a $1.4 million budget. The estimated appropriation authority was restored for the e-filing account, which gives them access to $15.8 million. That $15.8 is basically going to help fund the new case management system. $2.2 million related to the judicial pay bill to increase the salaries of all the children's courts associate judges. And the $258 that I mentioned for the one staff attorney to assist the appellate courts visiting judges is in our budget. Senate Bill 891, Megan mentioned, we received $300,000 to update the ancient weighted caseload study. $67,000 to create a public website for inventorying public citations and other legal notices. $80,000 to update the software that we use to track certifications for JDCC in order to add 2 new court reporter categories. And $300,000 to create a tracking system for various data associated with suits affecting the parent-child relationship. Our IT department's going to be pretty busy next biennium. We received, we were given authority to use $325 out of our e-filing account to create an internet-based protective order registry, and 2 FTEs and $280,000 for resources and support for the new Texas Commission on Judicial Selection. Moving to the Indigent Defense Commission, they received an additional $28 million appropriation. $5 million of that will go to public defender offices to develop a pilot project for early identification and specialized representation of indigent defendants with mental illness. Their cap on administrative expenses and their FT limit of 11 was released, so that came out of their authority. They were able to add if they need to. Unfortunately, they did not receive their estimated authority back on that fund. Last but not least, Comptroller Judiciary section, judicial pay bill added $24 million for increases for the district judges, attorneys, professional prosecutors, felony prosecutors, and county attorneys, and an additional $4 million for the retirement system. $9.4 million for the assistant prosecutor longevity pay. They expect a decrease in that fund, so they're offsetting that with additional funds, and they anticipate more prosecutors being eligible for this retirement. 1 new FTE for a prosecutor position within the juvenile division that focuses on sexual assault cases, and $3.3 million for the creation of the new judicial districts, statutory courts, and changes within the Professional Prosecutors Act. Looking at the appropriations comparing this biennium to next, you can see general revenue has increased by $55.3 million, fair defense increased 31. Judicial Fund 573 goes down $55.9 million, but I just want to point out, in 18 and 19, that money included the VW settlement funding, which is not available in the next biennium, but I've learned that there is a new Wells Fargo settlement that's going to add another $42.7 million to the fund, which will bring that up and reduce that shortfall. 3.1 in the Judicial and Court Personnel Training Fund, the $400,000 to bring sexual assault back up to $10 million. E-filing, that's the $15.8. That's going to go towards the new case management system. Small changes in some of these other funds. And this one on the bottom, Jury Service Fund, is a brand new fund created as a result of Senate Bill 346. So about $72 million added to the judicial branch budgets. This is a picture of just the appellate courts. Supreme Court, 94 million, Court of Criminal Appeals, 41 million. These graphs are also in the report you have with a little more detail with the numbers. I just kind of rolled them up here in millions. If you look at the entire judicial branch to see where our funding is appropriated by object of expense, 49% of it is salaries, 37% grants, 8% other operating, and the remaining 6% is all these other categories, small categories on the right. Last slide. This is just the judicial agencies excluding the appellate courts. 66% of the funding goes to the Comptroller's Department Judiciary section, 33% to OCA, and then the balance to the 4 smaller agencies. So that's it for the numbers, unless anyone has any questions.
Questions of Jennifer? Thanks, Jennifer. We really did have a very good session, and we're grateful to our legislative members, to Senator Zach Green, Senator Clayton, Representative Murr, Chairman Leach, all of their help, Senator Huffman, and Mr. Price, and many others helped us at both houses. Grateful to the leadership. Governor Patrick was very helpful, and the speaker. So we just really had a great session. When I said that Texas is becoming a leader on mental health issues, should have said that Bill Bryce, who I think's on the phone, has really been the leader in those efforts, and he'll get the credit if it goes as well as I think it's going to go one of these days. And we'll just appreciate all the work that Bill has done. Also, just on funding, the legislature restored the full general revenue appropriation for access to justice that they gave us in 2009 when we lost IOLTA because of the downturn in the economy and the lower interest rates. And then they let us keep the Hope Fund money from the Wells Fargo settlement. So that was $50 million that we got from the settlement of that case. At the governor's insistence, they doubled our money for legal aid for veterans from $3 million to $6 million, and restored the little cut that we took in the sexual assault victim money last session up to the full $10 million. So Betty Torres tells me that the veterans and the sexual assault victims program, which is called LASSA, L-A-S-S-A, have closed about 8,000 or 9,000 cases in the last not quite 2 years, close to 2 years. So that was money really serves a need. There are lots of clients in those that are being helped by that funding. So it was just a great, pretty great session.
Chief, and again, if I may add.
Yes.
And thanks to your testimony and David's testimony, I think that was very, very helpful in our success in passing legislation, and also the work of the Office of Court Administration. It now has a great reputation in both the Senate and the House, I believe, and that is very helpful to us. And we also have some key members. Senator Huffman did a fabulous job as Chair of State Affairs, and the State Affairs Committee members tended to co-author a lot of this legislation. That was very helpful. And also her Chief of Staff, Sean Opperman, is exceedingly supportive. And when there is a problem, he will help us identify it. Sometimes he doesn't even call me, he calls David directly. And so there are a lot of people who are very involved, and to whom we are grateful for that success.
Yep. Yes, and to David, who's just over there day and night through the session, who is a person of increasingly stern character. He has to suffer the slings and arrows of outrageous fortune over there. But, and to Megan, who was right beside him the whole time, and Bennett for all her help in the office. So just a lot of productive work went into this session, and the leadership of the council and our resolutions and the work that we've done is really well regarded across the street. So that just We just need to continue to build on that. Good session. We'll turn to setting the salary of the regional presiding judges.
Hello, I'm Mena Ramon with the Office of Court Administration. I'm the General Counsel. This agenda item is related to the salaries for presiding judges. This is a duty that's actually imposed on the Judicial Council. You are supposed to biannually set the salary for those regional presiding judges that serve as active judges. We have 11 in the state. 7 of them are retired, and the statute has an automatic calculation based on the number of judges and courts that they oversee. But for our active judges, those are those who have a district court bench as well. Judge Maderi, being here this morning, is one of them. They have 2 hats. They serve as a district court judge, and they're also serving in their role as a presiding judge for the region. For those judges, the Judicial Council is supposed to set their salary, and the statute has a cap that is currently set at $33,000. But as part of the judicial pay raise bill, that amount has been now moved up to 30% of the base salary, which would bump that up to $42,000. And the last time that that the judges got a raise was 2005. I don't know if anybody has any questions, but.
Any questions? So is there a motion to set the salary at 30%?
Second.
Any further discussion? All in favor?
Aye.
Opposed? Motion carries. Thank you, Nana. We need to consider rules amendments regards to reporting requirements because of changes in the statutes. David?
Good morning, everyone. David Slayton. I sent you all a memo on this issue. As Megan pointed out, House Bill 601 in particular changed the law with regard to reporting of mental health assessments. Before, it actually said in law that the magistrate should report that to the Office of Court Administration. The law was changed to say that the Judicial Council shall adopt rules regarding the reporting of those mental health assessments. And so we are proposing for you an amendment to address that issue. The amendment would be to 171.4 B1D and 171.5 B1D, as well as adding 171.6B subdivision D. That would basically take it in to allow the reporting for district courts, the statutory county courts, and the constitutional county courts as well, in compliance with the requirements of the law. That was what we were originally started to do with the reporting rules, but as we began to look at them, we found other things that needed to be changed based upon previous law changes or other actions taken, and so we're recommending a couple of other amendments. One of them is to repeal our administrative code rule 171.9A2, which the Supreme Court had ordered a reporting at one point, and they have repealed that order, so we have a provision in our rules which is no longer valid. In addition, we would recommend amending Rule 171.9D. There's just a reference in there to it's incorrect based upon a change in law. I believe it was last session with regard to reporting on judicial bypass cases. Recommending changes to Rule 171.9E to clarify who is supposed to report court security incidents to the Judicial Council. And so that change is made to, it used to be the local administrative judge, our rule still says that, the law now says it's to be the law enforcement entity that's providing court security for the court, so that's changed. We added a new 171.9G, which deals with reporting on writs of attachment. There was a law passed last session requiring courts to report writs of attachment in criminal cases. This is whenever a witness is basically taken into custody to testify in a case, and the law was changed last session to require that. So this would pick that up in our rules. Also, you might recall that the council adopted some rules with regard to regional presiding judges reporting to OCA, to the Judicial Council, and so that is added in 171.9H. And then we are recommending repealing sections 171.9G and 171.10B, which are provisions which require clerks to report to OCA when they're charging a $2 e-filing transaction report transaction. So those of you that are attorneys in the room will know that some counties charge $2 for every e-filed transaction, and that's allowed to be as a cost recovery. It was put in place when e-filing went into place. That provision expires September 1st, 2019, so that will no longer be allowed to be charged, and so we no longer have the need for the reporting requirement as it is. So that would be the changes that we would recommend there. We also, actually, I'll hold there because the next one's on a different agenda item. So those are the recommendations. You have a copy of the redlined rules in your. That would be our recommendation with regard to changes for the reporting of the council.
And I think they're fairly characterized as cleanup provisions, they're not intended to be substantive changes. They're involving changes in statutes and in our procedures. So, is there a motion to approve those changes in our rules?
Second.
Any discussion? All in favor? Aye. Opposed? Motion carries. Thank you, David. And then to the Collections Improvement Program.
So as you all may recall, those of you that have been around for a long time will recall many years ago, I believe it was in 2003 or 5, the Judicial Council worked worked with the legislature on a collection improvement program. This was meant to make sure that courts were using best practices with regard to collecting court costs and fines and fees in criminal cases. The council put in place best practices and then adopted rules that required certain things to happen. The legislature put that into law, required counties and cities of certain population to comply with those rules. And so that has been the process. As you might recall, a few years ago, we did a significant overhaul of those rules to address concerns about the way that those were being interpreted and so the practices that certain jurisdictions were using, especially with individuals who had an inability to pay the court costs and fines and fees. The counties and cities have long detested this program, have referred to it as an unfunded mandate, and have tried multiple times to get the provisions repealed from law. In addition to that, the legislature, after hearing from the counties again and cities again this session, also looked at the work that the council has done with Senate Bill 1913 that Senator Zaffarini passed last session, that basically instituted best practice into law, so that judges have to consider ability to pay at sentencing and take into certain, basically some of the provisions that were in the rules are now in law. And so the legislature included a repeal of the collection improvement program in Senate Bill 891 that passed and was signed into law. And so the recommendation here is to repeal the council's rules that go along with that. What this will do is basically default back to the provisions of Senate Bill 1913, which are now law, and there won't be any additional requirements placed upon counties or cities to do it. OCA will no longer be required to audit those counties and cities to make sure they're complying with the rules. But counties and cities are able to maintain their voluntary program, and I think many of them are planning on maintaining their collection improvement program practices, and we will certainly, we've sent out a letter to all of them saying we will certainly be available to provide technical assistance and continue to publish the best practices for this on our website and things like that, but they will no longer be under the obligation under that. So our recommendation is that you repeal Chapter 175 of the council's rules effective September 1st of 19 when the repeal of the law becomes effective.
So, Senator Zaffarini.
My first question is about the counties that have had so much trouble in implementing this program. What happens to them? Where do they go from here?
So there have been a few counties who have been held out of compliance with the rules. The penalty for a county or a city when they are out of compliance is that there's a financial penalty. They're not allowed to retain a certain portion of the court costs. They have to send all of it to the state. Most court costs, they're allowed to retain 10% as an administrative fee. That will no longer be allowed. or what is basically that would no longer be a penalty. So they would be able to begin to retain those court costs and fines. There would be no sort of follow-up audit to make sure they get back into compliance. It would just be they'd have to be following the state law. If there was someone if there was a judge, say, or a group of judges who were not following the state law with regard to what they're supposed to do with regard to determining ability to pay and assessments and collections and all that, then the remedy would be through the court system and not an administrative remedy.
Thank you. My second one has to do with the Courts of Excellence. How does the data related to this program impact our Courts of Excellence program?
So one of the requirements of the Courts of Excellence is that they are compliant with all requirements of the Collection Improvement Program, including the reporting aspects. Since this will be gone, that will no longer be it's part of the compliance section that we added. We're making sure they're in compliance with all requirements, reporting and otherwise. So that will just come out of the Centers of Excellence requirements.
So we may have more courts here to be recognized.
I know there's one in particular that might be of interest to you, so that it'll make the path a little easier for, I know, a judge in Webb County that is really interested in becoming a Center of Excellence, and that has been a significant barrier for that judge because the county is out of compliance. So.
And again, because of what was inherited.
Right.
Yep.
Thank you.
Right. Any other questions of David or discussion?
I move adoption.
Is there a second? Second. Any other discussion? All in favor?
Aye.
Opposed? Motion carries. Thank you, David. We now will have a presentation on the family law landscape, a subject that we should be turning our attention to in the future. This is a huge part of the civil docket. It's more than half. It's close to 55% of the civil docket in the district and county courts, and so we very important, obviously, to the parties and the lawyers. So we'll get a presentation on that. Jeff?
Thank you, Chief. So I wish this was another presentation where we could clap and smile and recognize people, but this is a lot of data and a few charts, but like the Chief said, this is an important topic, and it's one that's been looked at most recently very nationally. The presentation will, we're going to start and look at the status of family law cases nationally through an initiative that's currently going on. Then we'll take a look at Texas in comparison. We'll also talk about the Family Justice Initiative that's been conducted by the Conference of Chief Justices and this Conference of State Court Administrators. And then lastly, we'll wrap it up with a study that the OCA has been doing in partnership with a couple other agencies on the status of family law in Texas. So again, starting nationally, when we looked at, the Family Justice Initiative looked at the status of family law cases nationally. The numbers you're going to see on the next couple slides are the time period from July 2016 to June 2017. Their study took quite a bit of time, so that was the period of time that they could capture. So nationally, there's about 4.5 million cases in domestic relations that were filed in 2016. 3/4 of those involved divorce cases, and half of those divorce cases were cases that involved children. Nationally, 64% of those cases were uncontested, and they saw that cases that with kids and those cases that were reopened were more likely to be contested. 1 in 5 cases was reopened. So when we talk about reopened cases, we're talking about cases that had come to sort of a closed status at some point, but maybe there was a violation of the terms of the orders that needed to be addressed, and the case was reopened. In most courts, looks like 72% of those cases involved at least one self-represented individual. Also on the national landscape, pretrial conferences, which were considered meaningful case events, were held not too often. They look like for uncontested cases, 33% of the time, and contested cases, 53% of the time. So that sort of gives you a gauge of how much court time these cases are taking up. A very small proportion of those cases involve lawyers in combative or argumental arguments. And then a majority of those cases did not involve formal adjudication. So settlements, dismissals were some of the higher ways those cases were settled. Again, nationally, 75% of the contested cases were disposed within 12 months. One of the things that we really enforce when we do consultation with courts is model time standards for state courts. The standards say that 75% of divorce cases should be disposed within 4 months, but keep in mind that that doesn't include statutory waiting periods. In Texas, that is 60 days. So that varies from state to state. Those numbers could just vary depending on what you're looking at. Moving into Texas, we were able to look a little bit further. This is September 2017 to August 2018. In that time period, there were 380,000. So when you look at that compared to nationally, that's about 9% of the national caseload. And like the chief said, that accounts for quite a bit of the cases in the district court level. Domestic relations took up 54% of those cases, with 40 child support cases accounting for quite a bit more, 40%. And all these stats are in your handouts. Also looking at Texas, more than 60% of those domestic relations cases were new divorce cases. Compared to nationally, that was 76%. So the divorce rate, at least in filings in that time period, were lower than the national level. For reopened cases, about 1 in 5, that was the same at the national level. And about 40% of petitioners were self-represented at the time of filing.
Jeff, I have a question. Where do SAPSR petitions fall in that chart? Where they weren't married, so it's not a divorce proceeding, but it has to do with custody. Where does that fall in application to Texas?
David, do you know?
It's if you go to the next slide, it would be the one. Go one more. Sorry. So the parent-child relationship ones.
That's
the 8% there would be that. There might be some under other family law, but the majority of the SAPSR cases would be the parent-child relationship, that 8%.
Thank you.
Can you go back one more? I just want to point out one more thing. So you saw the stat that on the national that said, I believe, 72% of the cases involved one self-represented party at the national level, and you say, wow, Texas is a lot better. Just want to point out the difference in terminology here. We only capture petitioners that are self-represented. We don't capture respondents in family law cases that are self-represented. And what we know just from practice is that respondents are more likely to be self-represented. So 40% of people filing a case are self-represented at the time of filing. The guess is that a significant portion of the respondents are also self-represented. So we have a lot of cases where there's at least one represented party. I would believe that the number would be at least 72%. It would be consistent with the national level. So there's a lot of people in court trying to represent themselves in these family law cases.
And David brings up a good point, which I'll bring up later in the presentation, is it's just the level of data that we collect or we're able to collect from courts. It just didn't rise to the same level that was collected nationally. So just comparing those types of numbers, you do have to take some of those things into consideration.
David, can I ask a question?
Yes.
Since you've had the sheet now that you have to fill out with the informational purposes, now I know in Dallas County it has whether you're the petitioner responded and whether you're represented. So we still don't get to capture that information?
So that's a great question. And it leads to what we'll talk about later about the data committee. One of the issues, so the case information sheet that you're referring to, which by the way is now repealed because we're collecting it through the e-filing system, but we still have the data. That's data that exists but is not reported to the Judicial Council because we collect summary level data at the council level. We don't collect that level of detail. With the uniform case management system and the direction the council's headed, we should and could begin to collect that level of data so we would have it. The caveat to that is to say we most likely could get that information out of the e-filing system because it's obviously all, we have the data, it's all automated. So we could probably we could probably capture and see, say, within the last year, what percentage of the people as respondents are self-represented. The only drawback from that is that people who are self-represented are not required to e-file. So they could be filing in paper and we would never know that they were representing themselves. And my guess is a lot of those people are filing in paper.
May I ask
Yes.
a supplemental question? David, does that also capture SAPSR petitions that involve the Attorney General's office? Oftentimes, non-married parents will then go and dispute child support, and so a SAPSR petition rolls into all of that, and it's captured in our data that we're looking at.
Right. One of the things, Jeffrey, can you go back one slide? So one of the things I asked Jeffrey to do when we were looking at this was because we originally were looking at this, we didn't pull out the child support 4D cases, which is that, I mean, when we're looking at family law cases in our state, a lot of the cases are involving the cases being brought by the 4D agency, the Attorney General's office. So 40% of the domestic relations cases, 40% of that 50%, 55% are those AG cases that are being brought. So, and in a lot of those cases, the respondent is, almost all of those cases, the respondent is unrepresented. So it's a challenge there for sure.
David, are the paper filings that are occurring ever getting into the system, or are they just kind of outside the system at this point?
It depends on the county. Some counties have gone fully electronic, so they're scanning those documents and they're in electronic form, and that is the official. You know, clerks can now designate the electronic record as the official record of the court, and many clerks have done that. There are still some where they have a paper file and an electronic file. What should be clear as of right now is some of you all know about the Research Texas, which is basically the Texas version of the federal PACER system, the court document system. The only documents that are in that right now are documents which have been e-filed. So even if a clerk on the back end scans a document, it's not being uploaded into the Research Texas system. There was a law that was passed this session, House Bill 685, which we think will change that. Clerks have been concerned about their liability with documents being in the system, and there was a bill passed to make it clear they don't have any liability with documents in the system, and so we expect more and more of those documents to be uploaded to the system, which I think will help in lots of ways, including being able to see the data from our side of things.
Is that because of the redaction?
Exactly.
In terms of, yeah.
Briefly, we looked at disposition across Texas to compare on the national level. And the majority of those cases also did not involve a formal adjudication. 34% of those cases, as well as the reopened cases, did settle. We did break out the 4D and child support cases. There has been a significant increase for the last 5 years. And on average, about 2 in 5 cases were reopened, and generally that makes sense, as a lot of those cases involve minors. And that's consistent with the national trends. On the 4D disposition, again, majority of those cases did not involve formal adjudication. Quite a bit of them were dismissed. Time to disposition. Quite a bit of those cases, 58% were disposed within 6 months and 81% within 12 months. Again, the national standards were 75% within 6 months. It's a very, very high level chart. This just shows the percentage of cases, family law cases that were disposed, cases disposed over 12 months. The blue shades are where counties are doing really well. It's between 0 and 10%. There's one county that's between 60 and 100%, and for those interested, that's the county of King, which I had to look up, and is a population of 296 people. I did note that Webb County was doing well. They're in the blue for the 0 to 10%. Kimball County was in the yellow for 20 to 40%. So overall, these greens and yellows, that's your 10 to 40%. So overall, it looks like Texas is doing pretty well. There are some counties that could be doing better. The Family Justice Initiative is sort of what got us rolling on looking at the federal landscape. The Family Justice Initiative is a strategic approach to looking at family law across the country. There are several agencies involved. It's funded by the State Justice Institute for a grant. The National Conference of Juvenile and Family Court Judges is a big player, the National Center for State Courts, and the Institute for the Advancement of the American Legal System is also a big player in that. This initiative looked at 11 major urban areas across the country and looked at their case management systems. They looked at approximately 150,000 cases, and a lot of those numbers you saw, and a lot of the stats that you saw, they dug even further when they looked at these 150,000 cases. The amount of data they were able to collect from all these jurisdictions varied, just because the information that they were able to store in their local case management systems varied. But out of that, they had 13 principles which they felt were important to get out there for improving family law across the country. I'm not going to go into all 13 of them, but I have them all listed up here. I will just highlight a couple of them. Principle 2 was involving empowering parties. They felt it was important to proactively involve both parties in these cases so that the outcome was best suited to the families involved in the case. A few more principles. The one I wanted to put on this one was principle number 6, the streamlined pathway. They noted that 64% of the cases were uncontested, but they were still involved in the same judicial process as these complicated cases. So in caseload management, there's a theory called differentiated case management, where a court differentiates their basic cases from their simple cases from their complex cases. So you look at your cases and you determine what cases are going to take up a lot of resources and what cases aren't going to take up a lot of resources. So if you're having a lot of family law cases that are not involving a lot of resources because they're not contested, they just need to get through the process, there should be an easier way for that to happen. Here's the last 5 principles. Principle 11, ongoing data collection. This council has really adopted the principle that we need case level data. We need more data from across the state that we don't currently have. So we're hoping, with this uniform case management system, we're able to collect more data, be able to analyze that, especially in the family law area. In the last, I'll say the last several years, there was a group of individuals that came together and realized that we need to look at family law across Texas and take a look to see if the system's actually working, if there are improvements, if there are efficiencies, or even if it's just doing great. So there was a grant that was made available through the State Justice Institute, and the partnerships for this grant and the study were the Office of Court Administration, the National Council of Juvenile and Family Court Judges, Cynthia Osborne's team at the Center for Health and Social Policy at the LBJ School of Public Affairs at the University of Texas. And then we'd like to recognize Richard Shannon here. He's from the Enlightened Family Justice Institute. Richard's group made a financial contribution of $3,000 to the study, and we're thankful and appreciative of that. So this group brought together this advisory group. So you'll see we have judges, presiding judges. We have the Enlightened Family Justice Institute, the Texas Judicial Commission on Mental Health. We also have the Family Bar section. So a wide-ranging view of family court and how they're operating that was brought together. This group sort of met a couple times and identified several areas that they thought a study should be focused on. So what happened was last fall, Cynthia Osborne's group went out, did focus groups, did individual studies, just to get a lot of feedback on the system. They took a lot of that and developed a survey that was sent out statewide. It was sent out to about 5,000 individuals across the state. We're talking judges, attorneys, mediators, court staff. So those individuals that have some type of connection to the family court system. And they they were directed to do the study, and from that study, collect the data, analyze the data, and make some recommendations through a report. That report is due July 31st of this year. They were able to give me a draft report 2 nights ago. That was about 20 pages long. So in your electronic materials, we also have a paper handout. I did do a 2-page high-level, super high-level of a 20-page report from the findings. I really just wanted to go over, so it won't be up on the screen. Again, it's in your materials. The study had 3 overarching aims in which they were trying to collect information. One, they wanted to find out indicators that the family system is actually doing well. The second, they wanted to find out from the professionals in the system and that work within the system what their perceptions were and what their feedback was. And then the third area were if there were any gaps in the system. On that handout, we do a breakdown of the roles of the individuals. We do whether from rural or urban. We felt like that was really important information. Years of working in the system and gender. There were 5 key findings that came out of the study. The first one was court capacity. The second was resources to help families settle outside of court. The third was the access to representation for self-represented litigants. The fourth was connections to external resources, such as mental health treatment and substance abuse. And the last was identifying better indicators of the family court system. So I won't go over in depth what those indicators and what those findings really said. One of the areas that was identified as a concern amongst a lot of judges was the access to resources. Judges were finding that they didn't have the resources to treat individuals that were going through the system who did have a side order, such as a mental health order or a substance abuse order. They didn't have the time and they didn't have the resources. It just seems to be, for judges responding, it seemed to be a trend that was growing, that it wasn't just a divorce hearing, it wasn't just a child custody case. There were other issues that were sort of slowing that case down. But they didn't have access to those resources. And that proved to be true, particularly in rural areas where they didn't have the resources close enough for families to actually take advantage of. There were 5 barriers that were identified to individuals not having a good experience in the family court system. Mental health and substance abuse issues was one of those. The inability for families to afford an attorney was the second one. Parents representing themselves in court. As we said, there's large individuals that are self-represented. The true nature of the court system, it's become more adversarial than it used to be, or in some areas. And then litigants not having equal representation in court. Again, the study is still in draft. I'm bringing together this advisory group in 2 weeks to look at a final draft of the report. We're going to just talk about what came out of the study. One of the things I wanted to just highlight is it was a survey. It was a way to collect information from individuals that work within the system. There was no scientific method about it, but there are a lot of findings and a lot of common responses that we wanted to talk about. What we hope to come out of that advisory group is some recommendations to this body that this body and hopefully a committee will look at in depth and even further. This is a topic that is important, somewhat overlooked in comparison to other areas of the judicial system, and it involves a lot of people. One of the things that we talked about was the survey focused on attorneys and judges and court staff, but it didn't involve talking to people that actually go through the system. We didn't interview people going through divorces or the children, and that's an important aspect to this. And the views can be very different and critical. That will take a lot more time and a lot more resources, but we feel like that will be a recommendation that will come from this group. I can answer any other questions.
Questions, Jeff?
I have a question. You talked a lot about data and data analytic processes and so forth. How much of that data is actually going to be reaching the community itself?
In the community itself? I mean, we will release all the findings in a public report, if that's what you're referring to. It'll be a completely public report. the findings, in my unprofessional opinion, were not surprising. They are perceptions that I think I've heard quite a bit over the years, that it's a tough system. And, you know, on a personal level, my brother was going through a divorce in Texas many, many years ago. He didn't have the means to hire an attorney. They knew they needed to get through the process. Didn't know where to start, didn't know where to go. And when he actually did show up to court, he just felt like he was the enemy. But he was just participating in a process that wasn't explained to him. So it's just like any other type of court hearing. Individuals are thrown into a process that has rules and procedures that are unknown to them. So again, I don't think the findings showed anything different. It just showed that there is definitely a need, and I think the public will be happy to know that staff and judges feel the same way.
And with the family being the fundamental cell of society, any community outreach from that approach, and educating people and maybe trying to find other solutions besides divorce?
Yeah, I think that will be one of the things that comes out of the further studies for sure. Like I said, the study went as far as it could on the internal side. I think there does need to be a lot of community involvement.
Thank you.
Other questions?
I just want to point out one more thing, since Representative Murr mentioned it earlier. You know, more and more what we're seeing, and it actually is a growing part of the caseload, are the suits affecting parent-child relations, the SAPSRs, where there wasn't a divorce, there was never a marriage, and so now there's just children involved in a relationship, and then there's spots over custody and visitation and support and all those type of things, and so it's, you know, there's a lot of conflict going on in the court system with these cases, and as I think the study points out, the I think overwhelming cry from judges, and I've heard it personally from them, is what do? We don't have the resources to really help these families, and then the question is, what's the impact on the kids that, you know, they're going through these high conflict cases that maybe last over a year or more. It's something I think we've got to work on.
And I think, Chief, if I may, a lot of times, I know in Dallas County, a lot of the courts are looking towards social studies from counselors and making sure that they're making great decisions, because of course, you know, the judges only have so much time and they don't get a chance to see what's going on and see what arrangement is made. But you're absolutely right with the suits affecting the parent-child relationship. They're very serious cases and they need more resources to handle those. So. And I don't know how many people have the ability to have social studies being done or home studies, but they use those tools in Dallas, and I know those are other resources that people have to pay for. Not everybody can afford that.
Right. Well, this is an area, again, that is getting national attention, and as Jeff says, there's not a lot surprising in the preliminary report, and there probably won't be much surprising in the final report. We'll see it in a couple of weeks or 4 weeks. But we just need to continue to think about what our reaction to the information should be. And we've got a lot of players in the process. So the Children's Commission, very active in this, the Mental Health Commission, as well as the, as I said, national groups. So I want us to think about when we see the final version, what our involvement in all of this should be, how we can be productive, helping the court system or with draft legislation. We'll just have to see. Thank you very much. We'll turn to just briefly to the new business. So our procedure here, as you remember, is that we'll identify some areas that we've worked on before and maybe some new areas, and assign those to committees for review and study, and then get a report back along the way, reports back along the way. This past biennium, it worked very well for us to move up our deadlines a little bit so that we are completely prepared to draft legislation in the fall before the session begins. In the past, when we have still been working on resolutions in November, that just doesn't leave enough time to actually get the sponsors identified, the legislation drafted, and it's just much better for us. We can see this session if we are a little ahead of the game. So we'll try to do what we did last time and finish our work by June of next year, June in the summer. And then we'll look at the resolutions of August, and then we'll begin to strategize how we want to approach the legislature in the upcoming session. Yes.
And if our goal again could be to pre-file legislation, have it ready to pre-file in November before the January session. That's what made the difference this time.
Yeah, exactly. So are there slides on the committees? So we'll keep 4 committees that we've got already. And I want to add a new committee. So the 4 we'll keep. The next slide is...
Someone, I'm not sure who's running those slides. There we go. Thank you.
Criminal Justice Committee. So we'll continue to evaluate the bail reform, and frankly, I doubt that legislation is going to be a productive approach, and we can do this ourselves. The third branch can, and there are a lot of judges who want to do it already, and some have made a lot of progress in different approaches. In Harris County, the judges have, misdemeanor judges have adopted new rules. I know that Dallas is working on a program. They have to because they're under a federal court order to do it. Galveston is too. El Paso's working on one, and other jurisdictions are looking at it. So we will, our impetus this time will be, what can the third branch do to fix this problem without legislation, which should be everything we need to do, because judges are doing, they've been setting bail forever, so they can do this. We just need to help educate judges about the tools that are available. So if you get the recorder, which is the publication of the municipal judges, there was an article by a judge in Denton County several weeks ago who was skeptical about the risk assessment tool, and now is a believer. And so I think we're kind of getting a critical mass here together, and maybe we can make the progress we need to make ourselves. But we need to continue to think about that and how that's going to work, whether we need council rules to implement it, or just what we need to do. And then just looking at the Class C misdemeanor handling the cases generally, especially as they affect youth, which we've done before, but we just need to continue our work on that. That might require some legislation, probably will. And then you may know that there was proposed legislation in the last session to make changes in the grand jury process. It did not pass. I know the Governor Patrick was very supportive of it, and I think quite a bit of opposition to it as well. But we should add that to our list of things to take a look at. So will be the principal charges of this committee. And the next one is the Civil Justice Committee. And we've done a lot of work here already. We need to find ways to implement that work. Other courts are trying to do this around the country. And so that will just be a continuation of the work we've been doing. The business court proposition, again, in the legislature has not gotten a good reception, but there are other ways to fashion procedures for business courts. And other states have sought out judges who volunteer to take these cases, and with the agreement of the judges in the jurisdiction, and under special rules that are not that different from the usual procedural rules, just deadlines and pretrial orders and things like that, have made real progress, so we'll try to take a look at that. I know Tennessee has kind of the foremost one in the country, but a lot of other states do too. So we'll take that approach again. The legislature could have been helpful on this, but they didn't choose to be, so we can look at it ourselves and see what we can do in the branch. And again, other jurisdictions are looking at online dispute resolution. I think Utah has fully rolled its out. They just copied British Columbia, so it seems to be working, and we'll see how effective that is, and see what we can do about adopting something like that in Texas. And then we should monitor the Commission on Judicial Selection. Back in the 90s, some of you will remember, Governor Bullock and Senator Duncan got a change in judicial selection through the Senate 3 times, and it never got to the floor of the House. But it hasn't been studied since, and now the governor, as you saw in the update, the governor signed 3040 calling for the commission, and so we should monitor that and see what, if anything, we can do to help with their work. Next slide. Continuing the data committee. So now that we're going to get case level statistical data and a uniform case management system throughout the state, we will need to figure out how we're going to gather that information, what form we're going to try to put it in, what kinds of questions we would like the information to answer, all of those kinds of things. So I think this will be a pretty tall order for the data committee this time. And again, it might involve more legislation, but it may just involve adoptions of policies and rules for operating the data gathering system. Next is a new committee, and so as we're kind of shifting focus a little bit here we've been more focused the last several years on drafting legislation, and now we're going to shift a little bit toward just improvements in the judiciary that the judiciary itself can accomplish. And so we need to kind of think about how that's going to work. Whether we need additional budgeting for it, I don't know if we will. And just both from a point of view of authority and also pragmatically, what can we do to accomplish more of these initiatives and goals that we've been working on for several years. I just think particularly of the Civil Justice Initiative, because it's kind of like the Family Law Initiative in the sense that everybody knows what the answer is, and the whole country knows what the answer is. We just can't get it done. And the answer is you got to get the easy cases through fast and not let them clog up the courts. And you need to work harder on the big cases so they can get the attention they need. So, but it's just it's implementing that is a challenge. So we'll have that. And then the last one is one we keep again, public trust and confidence, and we just cannot ever lose sight of the importance of this. The third branch's authority rests on the trust that people have in the judiciary and the court system and the justice system. We just have to make sure that changes in perceptions, in politics, in society don't adversely affect what is our essential mission as the third branch. I know just for the Supreme Court, we did our the On the Bench program in Dallas County a couple, 3 years ago now, because of stories that we had heard, like you're voir diring a jury in a car wreck case, and the lawyer asked the denier, we're going to have a police officer testifying in this case. Is there anything about the fact that he's a police officer that would cause you to believe him or disbelieve him just because he's an officer? And almost every hand goes up. And so that's a very dangerous situation for us. We want implicit trust and respect in the system, and if we can make changes to make that better, then we need to do that. But some of that may involve trying to go on listening tours or something to make sure that we get plenty of public input into how our operation is being perceived. And then finally, probably when we see the report of the family law landscape, we will need to do some work on that. I don't want us to get overloaded, but that's probably going to need some attention as well. But I'll just kind of wait and see what the report looks like, and then decide whether we should have a formal committee on that or not. So you can be on any committee you want, and if you don't volunteer, then I'll assign you. But please volunteer, and you can be on more than one committee if you like. It's totally up to you. We want you to. I want you to do what you're interested in, and then if you'll let David know, just email him and say I'd like to serve on these committees. And if we don't hear from you, we'll email you and find out what your preference is, and get those set up well before the next meeting so that you can begin to try to get organized yourselves. And then by the fall meeting, we'll have a good idea of our direction. So questions about that?
I
Yes.
just have a question.
Yes.
And I think I brought this up last time, but we are in the ushering of the fourth industrial revolution, meaning there's a lot of new technologies and new inventions and new things coming to pass. And I do work in Houston with the largest oil and gas companies, Exxon, Chevron, Shell, and many more. And my question is, what kind of legislation is being set in place for all of these new things that are coming into the future? And basically they are here. You know, I'm visiting mud holes, for example, in the bay in Galveston Bay, where, you know, we just see all this equipment and machinery working, and what kind of laws are in place in case of injury by some kind of robot, or if you look at the process of a 3D printing project, a 3D printer can copy exactly to the T of the molecule of something that is designed and is patented and owned by somebody. So any type of legislation looking into all these new things, we have new technologies that I think as a core we need to be informed and know exactly what it is, virtual reality, artificial intelligence, robotics. It's just beyond analytics that, what is going to happen with cars when they are just self-driven? What kind of laws, legislation is being put in place for all this?
It's just kind of hit and miss, I think. And this is all, and you're exactly right, it's moving at such a fast pace. I've heard 2 presentations, just as it happens, in the last 6 weeks about artificial intelligence. And after I have a 5th drink and kind of calm down, it's kind of scary. I mean, it could be very helpful, and you've seen them in the ABA Journal and the about how it's going to affect our profession. Maybe we should expand the data committees. Maybe it should be data.
The scope should be expanded, at least for that committee, because this starts with data, exactly.
Yeah.
But for example, I'm working with Stanford Business and Harvard Business on a particular study that actually by zip code level, we can look at the zip code and tell you exactly how many jobs you're going to lose as a state or as a county by just the simple fact that you are, or you're going to have to bring automation in order to be productive and keep up to speed with everybody else. So if you are interested, I'll be happy to bring some kind of sample of what data is. I think it's extremely important to you guys, and as legislators, I'm not an attorney, you guys are the brilliant minds, but I'm just telling you what I see in the world out there of technology and science, and to me that's very important and very relevant.
No, you're exactly right. Yes.
In the past, we've had committees that have focused on persons with intellectual disabilities, we've focused on mental health, we focused on the elders, we've called different committees by different names. But for a while there, we were focusing on developmental disabilities and also physical disabilities. Where would those subjects, including guardianship, be addressed? Would it be in civil justice, perhaps? How do we ensure that persons with disabilities have access to justice?
In civil justice.
Yeah, and one of the things that we're transitioning a little bit, we're going to be working closely with the Judicial Commission on Mental Health on those type of issues. Christy, who's here, the Executive Director, we've worked with them on similar to the way the Children's Commission does, that they will actually have a legislative committee that will look at these type of issues, study them, and then make recommendations to the council, similar to the way the commission, Children's Commission does. So they will be focusing on that area, delving in very deeply to that, and then making recommendations back to the council. That will
But
then,
separate from mental health, intellectual and physical disabilities.
I believe that's also included. I don't know.
I believe it's
Christy
definitely
speaks.
included in our mission, and I agree with you that physical disability should be.
Separate from mental health.
Yes.
Absolutely.
Whenever the Supreme Court and Court of Appeals were considering the mandate for the Judicial Commission on Mental Health, even though it refers to it as the Commission on Mental Health, they specifically wrote in a broad authority to deal with intellectual developmental disabilities, other types of disabilities too. So I believe that the Commission can deal with that. I believe it's on there. I know there's been specific discussion about intellectual and developmental disabilities in particular, because it's an area that's been somewhat understudied and underlooked at in the system. And so I know that's what we had asked from the council side. I've talked to Christy about this a couple of times, is for them to look at those issues. I know they're already kicking up their legislative work and beginning to look at the next session. And basically the thought would be that if there's any recommendations that the judiciary needs to make changes on its own, that those could come back and the council could take a look at those as well with any legislative recommendations.
Well, at one point we separated those because we really didn't cover intellectual disabilities or physical disabilities under mental health. And frankly, nor should we. I mean, those are different areas.
Right. True. Yeah, I think there may be separate committees even dealing with that over there. I'm not sure exactly. Christy,
Yes, there is a separate group that is interested in IDD specifically, but I hear your suggestion that physical disability is not addressed in our mission right now, and I can bring that to our leadership.
It's totally different from mental health.
Sure.
Please tell David what you prefer to work on. And every every year, I think the influence of the council grows, and so I would like that to continue and maybe even accelerate in the next 2 years. Because some of this is getting pretty pressing. So we don't have a meeting yet for the fall, but we'll poll you in the next few days and find the time for the next meeting. And by then, as I say, we'll have the committees and we'll be getting to work. Anything else under new business? Well, then we will stay adjourned. Thanks for coming. Good to see you.